Hello and welcome. You're watching Nothing But the Truth. The already complicated Uttarakhand controversy took a turn for the worse on Friday when Congress challenged the government's decision to issue an ordinance to pass the Uttarakhand Appropriation Bill. This latest development adds to the list of developments that have created battle lines between Congress and the BJP. With me to talk about this development as well as the wider Uttarakhand controversy is former Law Minister and the Congress Party's principal lawyer fighting its many cases in the Uttarakhand High Court, Kapil Sibal. Mr. Sibal, let's start with the reason why Arun Jaitley believed the Uttarakhand government had to be dismissed. He says there was a clear majority of 35 versus 32 over the appropriation bill, which means it cannot be passed by voice vote. In truth, he says, the appropriation bill was defeated, and because it's a money bill, the government was defeated as well. And thereafter, the government continued to stay in office illegally, which is why it had to be dismissed.
So it's Arun Jaitley who will decide whether an appropriation bill was passed in the assembly or not. It's the cabinet in India which will decide that, or is it the speaker in the assembly who will decide that?
You see, there's no doubt that the speaker has claimed that the appropriation bill was passed, but the Times of India says on the 30th of March that no such bill was recorded as passed in the assembly's records. I want to read from the paper. While the opposition's demand for a division was ignored, no specific vote either in favor or against the motion was recorded. The sequence of events in the assembly, along with a video recording, shows that when the appropriation bill was being passed, a demand for a division was raised under Rule 296(1). Neither this nor a vote by show of hands nor any other vote took place.
Well, is the Times of India going to decide whether a vote took place or not, or it was done by a show of hands? As you know, under the Constitution, it's the Speaker of the Legislative Assembly who decides. And there is no constitutional requirement that there must be voting on the appropriation bill. It was passed by voice vote, and a certificate to that effect. Certification to that effect was sent by the Speaker to the governor.
Except for the fact that the certified bill wasn't sent for 10 full days. That's another reason why people are suspicious.
No, that's not correct.
Well, the bill was passed on the 18th, the Speaker says. The certified copy reached the governor 10 days later on the 28th.
That's not correct. That's not correct. It was sent immediately.
So reports to the effect that it didn't reach the governor to the 28th are inaccurate.
Completely wrong.
But they've been in every paper.
Oh, that's wrong.
And in fact, I believe BJP spokesmen have been quoting them.
Let me tell you another thing. When the Speaker certifies that a bill has been passed, the governor cannot refuse consent. So it's a money bill. It's a money bill.
So in other words, the Speaker's verdict on the bill being passed is the final word.
Yes, the Constitution says so.
What about the fact, if it is correct, that the records of the Assembly don't show a vote happening of any sort whatsoever?
Not necessary. Not necessary for a vote to happen. Remember, when demands were made by Harak Singh Thapar Quay's own ministry, they were passed. He got them passed. And after the Speaker declared that the appropriation bill is passed, then they raised a demand. But that issue cannot be, look, that issue has never been challenged in any court. Remember that. That issue is not challenged.
So on this issue, the Speaker's word is final?
Always, under the Constitution. If it's a money bill, even the governor cannot say withhold consent.
All right. Since then, the central government has actually issued an ordinance to pass the Uttarakhand appropriation bill on the grounds that the Assembly didn't do so, despite the fact, as you say, the Speaker insists it has been passed. Two things emerge from this. First, the central government is not accepting the Uttarakhand Speaker's word. And secondly, the central government has arrogated to itself the right to determine whether the Uttarakhand Speaker is right or wrong.
It's just unbelievable that the cabinet in Delhi will decide whether a bill has been passed in an assembly or not. It's unheard of. In 60 years, 8 years of constitutional history, this has never happened.
Beyond being unheard of and unbelievable, is this step by the central government unconstitutional?
Completely. Completely. The cabinet has arrogated to itself judicial power. If at all anybody challenges what happened in the assembly, and the court really can't go into it, but assuming somebody were to challenge it, it's the court to decide, not Mr. Jaitley sitting in Delhi.
So there are no set of circumstances under which the central government, perhaps on the advice of the governor of the state, can decide that the Speaker's claim that the appropriation bill is passed is wrong, and therefore an ordinance is needed.
Remember this, even the governor, say the appropriation bill was passed on 18th, the governor called the chief minister and said, prove your majority on the 28th. If he knew that the appropriation bill had not been passed, Why would he ask the Chief Minister to prove his majority on 28th?
Quite right. If he knew the appropriation bill hadn't been passed, that means the government has fallen.
Exactly. Then how would he ask him to prove his majority?
So the fact that he asked him to prove his majority means the government has accepted the bill was passed.
Obviously. Otherwise, he wouldn't ask him to prove his majority.
Now, on Friday, as I said in the introduction, the Congress party, working through as their lead lawyer, has actually challenged the ordinance in the Uttarakhand High Court. Do you believe an issue as complicated and sensitive as this can be settled at the High Court level, or will it inevitably go to the Supreme Court?
Ultimately, it will go to the Supreme Court.
That's inevitable.
Oh, absolutely.
In which case, this problem will rankle for days, weeks, possibly months before it's sorted out.
Absolutely.
So the mess in Uttarakhand is likely to continue for a long while.
Created by the central government, yes.
But it will continue for a long while.
Yes.
Let's come to a second reason why the Uttarakhand government was dismissed, this time a reason advanced by the Attorney General Mukul Rohatgi to the Uttarakhand High Court. He said that the government had to be dismissed because horse trading had begun, and if it wasn't dismissed, horse trading would continue and get worse. Therefore, it was dismissed at once. And the so-called sting video done by Samachar Plus seems to bear out the point Mr. Rohatgi is making.
So therefore, somebody should know what the definition of horse trading is. Horse trading means that if a party tries to poach members of another party. So in fact, if there is any allegation of horse trading, is against the BJP because they poached the members of the Congress party. You can't be doing horse trading to bring your own people together.
You're making a very interesting distinction. Horse trading is when you pay money to buy votes from people who are not your party members. But you're suggesting that the payment of money to your own MLAs is not horse trading.
I didn't say there is any payment, but I'm saying that's not horse trading at all, because these 9 MLAs have said they have not left the Congress party. So how could there be horse trading?
Well, just a moment. In fact, Bahuguna has gone on record to say that the distance between him and Congress is so great, there's no question of returning.
That's another matter.
So if he's not returning,
but they
he's
are
left.
not left the Congress.
But if he's not returning, he's left.
No, that's not their case. They have gone to the High Court to say that there cannot be any disqualification, because there is no voluntary resignation to the party.
Oh, no, just a moment. They're saying there can't be any disqualification because the disqualification happened after President's rule was passed.
No. They say there can't be disqualification because we have not voluntarily resigned from the party. We are still congressmen.
We're in danger of mixing up two issues, the disqualification with the sting video. Let's take them one by one so the audience can understand. I'll come back to the sting video.
All right.
Mr. Rawat says that it's fake, it's fraudulent. But there's no doubt that in the video, you hear him discussing cash, you hear him discussing ministerial positions, you hear him discussing corporate positions. In one instance, he says that if one of the defectors were to return and become a minister and then use his portfolio to make money, Mr. Rawat would look the other way. Now, Mr. Rawat can't deny saying these things because we've all heard him say them.
Karan, we are not going to go into whether Mr. Rawat denies it, doesn't deny it. This sting operation has happened. Some authority will have to decide what the consequences are, if it's genuine, not genuine. He says it's fabricated. That can't be the basis of a breakdown of constitutional machinery. Remember, there was a sting in Arunachal. There was a sting in Arunachal where a BJP fellow is talking to a businessman, a congressman is talking to a businessman and saying that he has met Modi. He's got clearance from Modi, he's got clearance from Amit Shah, and money is to be paid to the Congress people. That sting they don't accept. That is part of the judicial record. They should have imposed President's rule then.
So
now this thing they accept, because why? It serves their political purpose.
So there are dual standards here.
Absolutely.
You're saying two very...
Who is the government of India to accept?
You're saying two very important things about the sting video. First of all, it can't be horse trading if you're actually talking to your own MLAs.
That's right.
Horse trading only happens when you're poaching someone else's MLAs.
Absolutely.
Secondly, you're saying the authenticity and credibility of that video has to be established, and the central government or the governor can't establish it. A court has to establish it.
And you prosecute the man. If somebody has done something wrong, you prosecute him. It's not breakdown of constitutional machinery. That man will go, somebody else will be chief minister.
So to wind up this particular section of the interview, you're saying neither the appropriation bill issue and the claim that it wasn't passed, nor the sting video provide grounds for dismissing Mr. Rawat's government.
Absolutely. And remember this, if appropriation bill had not been passed on the 18th of March, why did they wait till the 31st to issue the ordinance? Please tell me. The reason why they did it, because the Congress MPs challenged the notice of the Speaker for disqualification. Had they got a stay of that, they would have gone ahead on the 28th with the voice of vote, and Harish Rawat's government would have fallen, and they wouldn't have bothered about what happened on 18th of March. It's because they could not get a stay, could not get a stay and the writing was on the wall that they'd be disqualified, the central government imposed president's rule.
All right. Let's now come to a second critical issue or development connected with the Uttarakhand controversy, the decision or the order of the Uttarakhand High Court to order a floor test. Despite the fact President's rule wasn't stayed, and despite the fact the Assembly continues to be in suspended animation. Now, that order for the time being is in abeyance, but depending on what the High Court decides next week, it could be acted upon. Many people believe that this order is actually, forgive the word, nonsensical. How do you, as a lawyer, view the order?
First of all, I don't think it's appropriate for me, when that very matter is pending in appeal in the High Court, for me to make comments on that order. The order was passed after hearing both sides, and on agreement, that order has been stayed for a while.
Okay.
And the appeal court will decide.
Okay, I won't tempt you to make comments about that particular order. Let's come to something critically connected with that order, which is the status of the 9 Congress MLAs who were, in your eyes, defectors and who were disqualified by the Speaker. That is critical to the floor test. How they vote will determine which way the floor test goes. Now, Congress says that their disqualification is legitimate and legal. They say that because the disqualification happened after President's rule was declared, after the Assembly was put into suspended animation, it's illegal.
Well, actually, they're wrong on both counts. Number one, it really doesn't matter when the order of disqualification was passed and when the 356 was imposed.
Why does it not matter?
Because it's an order under the 10th schedule, where the Speaker acts as a quasi-judicial authority. Merely,
is the Speaker's position under the 10th schedule not affected by dissolution of the House or by putting
First
the
of all,
Assembly
this
in
is not
animation?
dissolution of the House.
Putting the Assembly in suspended
Not at all.
animation?
He cannot perform legislative functions, but he can perform quasi-judicial
So
functions.
his quasi-judicial function under the 10th schedule continues even after
Absolutely.
President's rule is declared?
Absolutely.
Even after the Assembly is in suspended animation?
Absolutely. And factually, I think the Speaker passed the order at 2:40. And at least the gazetted proclamation came at 5:40 in the evening. But these are facts that will be investigated
Well, you're raising
by the
a
High
second
Court.
issue. This is to do with when it is to be deemed the actual putting of the state under President's rule happened. Did it happen at 12 noon when the President signed the proclamation, or does it happen at 5:30 when the Gazette of India publishes it? Which of the two, in your eyes, is it?
First of all, I don't think the issue is relevant. But even if it's relevant, it's when the Speaker passes the order that's relevant, because the proclamation has no impact on the exercise of that power.
Because, in fact, the Speaker's powers under the 10th schedule continue regardless of whether the state's put under President's rule.
Yeah.
But just for argument's sake, if in fact the timing of President's rule is 12 noon when the President signs the proclamation, not 5:30 when it's published in the Gazette of India,
it doesn't matter.
Then it happened before the disqualification.
No, it's when it's gazetted. It's when it's known to the people.
You're sure it's the gazetting time that counts?
I think so. That's how it should be. How do I know that I can't pass an order?
When you say I think so, you're not sure?
No, naturally, because things are, remember, everything is not black and white, both in life and in law.
So this is
the courts will have to decide.
The courts will have to decide this one. Are you confident that on the disqualification issue, your stand is correct?
Confident. They are already disqualified. They can't vote anymore.
One more question. It may be hypothetical or academic at this point, but it's one of great interest to people. If, and it's a big if Mr. Rawat were to win the floor test whenever it happens, or if it happens, would he immediately be reinstated as Chief Minister, or do we still have to wait for President's rule to be overturned either by the courts or revoked by the government?
There's no question of reinstatement as long as 356 is there. Once
so that has to be revoked
the proclamation
first.
of emergency is there, we've challenged both the proclamation of emergency as well as the ordinance. Remember, I want to raise another point, if you allow me. The Parliament was prorogued. Remember?
To be able to pass the ordinance.
Why? Why was Parliament
to
prorogued?
be able to pass the ordinance?
No. If the 356 had been imposed, assuming appropriation bill had not been passed, they could have passed the appropriation bill in Parliament before the 31st. They would not pass it. They don't want Parliament to meet for the reason that they would have lost in the Rajya Sabha before the 31st. So they had to prorogue Parliament. So they prorogued Parliament to issue the ordinance. The whole thing is nullified.
That I understand. But to just come back to that academic point I raised about Mr. Rawat, you're saying to me, if I understand correctly, that even if he were to win the floor test when and if it happens, he still wouldn't be reinstated until President's rule is revoked.
Absolutely, because then the governor would be told that he has won the floor test. Governor should then recommend to the President to the union government that that 356 should be lifted.
So, and it may not be simultaneous. There could be a lag or a delay between the two.
There may be a lag, yes.
Let's now
But before that, the High Court judgment may come, may not come.
Striking it down, may or may not.
If at all, that's for the court to decide.
Let's come and look at the role of two other institutions in the Uttarakhand controversy. First, the governor. Governor Paul first insisted on a floor test. He set the date of the 28th of March. 24 hours before that floor test were to happen, he changed his mind and recommended dismissal of the government. For most people, that's an apparent U-turn. How do you view it?
First of all, Karan, I don't know what the governor recommended.
Well, it's in all the papers.
No. I can't now start believing newspapers and making my comments. The matter, the records will come to the court. We'll know exactly what the governor did. I don't want to criticize a constitutional authority on newspaper reports.
You're saying something potentially very interesting, that it's possible the governor did not change his mind from wanting a floor test on the 28th and recommend dismissal of the government. It's possible he never made that recommendation of dismissal.
It's possible.
In which case, that would suggest that the centre acted on their own without a governor's recommendation.
Remember, current centre had already decided to do this. They want a Congress Mukt Bharat. They will dismiss and destabilize every Congress government. The next is Manipur. As I talk to you, the next will be Manipur.
Of course, under Article 356, the centre does have the power and the prerogative to dismiss a government even without a governor's recommendation.
That's correct.
It's not necessary.
Or otherwise.
Or otherwise.
Yes.
All I'm questioning is this. Why did the governor change his position from wanting a floor test and then 24 hours before the floor test dismissing the government? You're saying it's possible the governor never did change his position.
I'm not going to criticize any constitutional authority based on newspaper reports.
But you're also suggesting
yes,
it's possible the governor never changed his position.
It's possible.
The centre took a position different to the governor. The governor may have stayed loyal to his original decision of a floor test on the 28th.
It's possible.
That is possible.
It's possible.
Let's come now to the role of the president who actually signed that proclamation. If I understand the facts correctly as published in the newspapers, and I should add not disputed by any BJP spokesman I've spoken to, Mr. Jaitley met President Mukherjee sometime after 9:30 at night, maybe even after 10 p.m. on Saturday the 26th. Slightly more than 12 or 13 hours later, at noon on Sunday, the president signed the proclamation. The first question people ask is, should the president have given himself more time to reflect more closely, to analyze more carefully before signing? Was 12, 13 hours too quick?
First of all, I don't think, again, that I should be commenting on the highest constitutional authority in India. And on his conduct, it would be inappropriate for me to comment on that. But secondly,
your party spokesman, in an interview to me, or a discussion rather, Manish Tiwari has done so, speaking for himself, not the party.
As I
he
said,
did say that he thought the president should have taken longer.
I am sitting before you as a representative not only of the Congress party, but as a lawyer who does not believe in shooting his mouth on issues that I'm not aware of. I don't know exactly what happened between the president and Mr. Jaitley. All I can say is that if the authorities had addressed themselves to Article 200 of the Constitution, which says that if a money bill is passed, the governor cannot refuse to sign it, none of this would have happened.
And additional to that is the fact that the Speaker's comment or decision about whether it's passed or not is the final one on a money bill.
Absolutely.
The second comment or criticism made about the President is this. Given that a floor test was due in 24 hours' time, and secondly, given that the Bomai judgment very clearly stipulates that the majority of a government has to be tested on the floor of the Assembly, not in Raj Bhavan or Rashtrapati Bhavan, people say President Mukherjee should have done what President Narayanan did first in 1997 in the Kalyan Singh case in UP, and then again in 1998 in the Rabri Devi case in Bihar. On both occasions, he asked the government of the time to reconsider. Do you think President Mukherjee should have done the same thing with Uttarakhand?
You must remember the Constitution says that even if the President had asked them to reconsider, if they send it back, he has no choice in the matter.
Absolutely, but remember when President Narayanan twice asked, first Gujarat and then Vajpayee, to reconsider, on both occasions they did, because the moral authority of the President is so great, it forces governments to rethink. And when governments are sailing so close to the wind, as you allege the Modi government was in the Uttarakhand case, Mr. Mukherjee might have made them pause and reconsider.
I'm not going to second guess as to why the President did this. It's not for me to comment on.
Do you think he should have?
Certainly not. I'm not going to comment on it.
Let me point out to you that Manish Tiwari is speaking as your spokesman, but adding that he was only giving his personal opinion, not the Congress party stand, did say that he thought, personally, President Mukherjee should have asked for reconsideration.
In matters like these, I don't believe in giving personal opinions.
All right. We've spent about 20 minutes so far discussing the role of 6 critical institutions in connection with what I and the press calls the Uttarakhand controversy. Those 6 institutions are the Speaker, the Chief Minister, the Governor, the Prime Minister or the government, and the President. The 6th is the Uttarakhand High Court. There are many who feel that all 6 have not acted in a way that one would have expected them to act in a controversial, difficult, tricky situation. Each of the 6, in their own different ways, has actually let down India's high expectations of them.
You must remember that when institutions act and individuals act, they do it looking at the institutions in the context of what the institution should do, and individuals in the context of what the politics is. I think you should separate these two things. The central government here was hell-bent on destabilizing Uttarakhand. Everything that they have done from the 18th of March was for that particular purpose. Harish, on the other hand, was wanting to make sure that he continues as Chief Minister. Everything that he did was for that political purpose. And the institutions were trying to understand why all this is happening and doing the best they can in the context of what was happening.
I hear your explanation. I also notice the distinction you're making between institutions and individuals, and is partly designed, no doubt, to protect Harish Rawat and the allegation that he was bribing, in quotations, his own people to make sure they don't defect and vote for him. But I'll leave that aside. The point I want to make towards the end is this, that for the Indian people, for Indian democracy, it's a bit distressing. I think that's the right word, distressing, that 6 critical institutions, presumably each acting independently of the other, should have all fallen short of the expectations that people would have of them.
You know, I think that what the High Court did, what the single judge did, ordering a floor test, is consistent with Bomai, except that there was the 356 proclamation in the way, which was not staged.
A major obstacle in the way, which he didn't either realize or consider.
But he was not saying that, look, he said that this will be put in a
and complicated further by the way he treated the defectors.
It will be put aside till such time as the 356
and complicated by the way he treated the defectors.
What else could he do at that point in time? Or say, let's hear the matter.
He could have struck down 356 altogether.
You can't. No, you can't. Without hearing, you cannot. This was at the admission stage. You remember that. That's why the division bench on an agreed order says we'll decide the matter.
So you're saying to me that although public opinion feels distressed that 6 independent institutions connected with the Uttarakhand controversy have not lived up to high expectations, there are explanations for each of those 6, and therefore the belief that this is distressing may be an exaggerated belief.
Well, you know, you can always find negative things about every action in life, and depends on which perspective you look at. I mean, the BJP will say and the central government will say, we are fulfilling our political objective of destabilizing and having a Congress Mukt Bharat. Everything is good if we can achieve that objective. And Harish will saying, I'll do everything to protect my government.
I hear what you're saying, Mr. Sibal, but people will turn around and say, isn't it an amazing coincidence that the Speaker, the Chief Minister, the Governor, the Prime Minister or the government, the President and the Uttarakhand High Court, all 6 acting independently, came up with decisions that are falling short of the expectations that people have.
The nature of politics is such that this happens. It happens not just in India but everywhere in the world. See what's happening in the US.
But 6 institutions together over one sorry affair?
It depends on the issue. It depends on the issue. These are institutions. The same thing happened in Arunachal. There were similar institutions in Arunachal. So one judge was passing one order, another judge was passing another order.
That only adds to the problem, doesn't it?
The alleged speaker's role, the deputy speaker's role, the High Court's role, ultimately the matter is now we haven't got a judgment even in the Supreme Court.
You're actually, in a sense, proving my point by illustrating it through the Arunachal example rather than the Uttarakhand example. And the conclusion I come to, or at least many will come to, is this.
We are deeply distressed.
That this is a sad commentary on our politics and our democracy.
I personally, and this is a comment I can make personally, I'm deeply distressed by the manner in which democracy is functioning in this country.
And Uttarakhand is a horrible illustration of that.
I agree with you.
Kapil Sibal, a pleasure talking to you.